confirmation report, meaning you got to stay here the whole time, unfortunately. And will be sent via email within 48 hours following the webinar. These credits are not transferable. They're only good for you. Please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about receiving your CMA certificates. And with that being done, let's get started into this wonderful presentation. It was a glorious year. The legislature took direct aim at associations. Also, there really wasn't a whole lot in the case law world, so we excluded that, but I have a lot of statute stuff. So let's go ahead and get started on this one, because this year was deemed by me the year of HOA abuses. HOA's got a really, really bad rap this year. The session in HOA land, at least, was all about Green Valley Ranch and Florida. The foreclosure numbers that came out of the Green Valley Ranch community struck fear and awe inside the legislature. That this was an example of an HOA gone amok. If you actually look at the numbers, it was clearly not that, but that's how the public outcry surrounded. The battle cry was associations are out of control. They don't know what they're doing. They have too much power. Thus, all sorts of regulation and the attempt to rein associations in. Whether that was true or not, yet to be seen. But that's what the battle cry was. So look at some of the unsuccessful bills. The first bill was HB 22-1139, and this was a revamp by Representative Titone of trying to regulate community associations through the managers, but really it was the management companies. As you might recall, Colorado's CAM licensing was allowed to expire 2-3 years ago, 2019. And there were a group of owners, group of people asked for a sunrise report to look and see if manager licensing was really needed. The report came out, and Representative Titone introduced a bill to regulate not really association managers, but management companies. Again, to try and get hold of everybody in the industry and put some sort of regulation and penalty and enforcement with the Department of Regulatory Agencies on management companies. This was postponed indefinitely and withdrawn relatively quickly, but it kind of shows you that, again, this issue is not going away. And this issue continues to be of concern to some in the legislature. So we'll have to see what happens next year. I doubt it will come back under Governor Polis's watch, but always something to look for. And then HB 2260 was a bill that really I don't understand the need for it. It was a bill that was intended to limit fee increases for the use of common areas. And really what this was is it wasn't so much the cost to use the cost to maintain common areas, but it was if an association has a fee to use the common area, the rent the clubhouse, or if they charged a fee to use the pool, it would limit the ability of an association to raise that year over year. And why this was a problem, I don't know, because really all it would have done was put the burden back on common expense assessments to maintain these if you are limited in what you can raise by those that are using it. Again, this was killed relatively early on, so it really didn't get far into development. So past that, we have, those are the only two that really did not make it and didn't go anywhere. More on that topic later. But what we have is those that have actually been signed. So HB 22-1040 is titled Reasonable Access to the Common Areas. And I have gone out and I think this is going to end up being a sneakily complicated bill. I believe this came out of the pandemic when many associations closed their pools because it was cost prohibitive to open the pool with the mandatory sanitation and social distancing. So a lot of associations just closed the pool for the season. And I think it caused a great outcry, particularly during the 2 summers of COVID, of where are my kids going to go and how am I going to use the, now I have to go find someplace else to dump my kids. And I'm sorry, I'm just being a little facetious, but that's really where it came up. So this brainchild came out, and what this bill says is it requires an association to preserve and protect an owner's ability to use and enjoy the common elements. Meaning you now have an affirmative duty to make sure your common elements are open, they work as intended, and you can no longer just close a common element for convenience or lack of budget because you can't repair it. There are associations out there that I'm aware of that just close their clubhouse because they don't have the money to repair it and make it usable. Well, I think that option is now gone. This has been signed into law. It says you cannot unreasonably restrict or prohibit an owner's access to enjoyment of the common elements, even during maintenance, repair, and replacement. Meaning that even if you are repairing it or replacing it, you have to be able to use the common element. I could make an argument that if I wanted to go out onto a pool deck in the middle of winter, I should be allowed to go onto the pool deck in the middle of winter because you have an obligation to not unreasonably restrict or prohibit an owner's access to or enjoyment of the common elements. And the pool deck is a common element. I may not be able to swim in December, but I should be able to go suntan on a nice day. You may only close common areas for a minimum amount of time necessary to protect the safety of persons during the performance of the maintenance and structural integrity of the common element. So again, it gets to, if you have a hot tub and you want to close the hot tub because it's leaking and you can't get a pump, and you decide not to expedite order of a pump, that's probably not a reasonable closure of that common element. It's only for the absolute minimum amount of time to perform the work, and it's only to protect the people, the population, your owners, or the maintenance crew, or the structural integrity. If you can keep a part of the common element open during construction, you are required to do that. If you are going to close the common element for more than 72 hours, you must post notice on the common element of the reason for the closure, the anticipated opening date, and the name and address, or the name and phone number of somebody to call to address or discuss the closure. This is, like I said, this is a sneakily problematic bill. It is going to require you get on top of maintenance of the common elements. It is going to require you perform the maintenance in a way to keep the common elements open. And you can only close them for the absolute minimum amount of time necessary to make the repair. And if you can find a way to keep it open during the repair, you're required to do so. Okay. SB 22059 was proxies, and they cannot be valid for more than 11 months. The previous statute stated proxies were good for 11 months or whatever other date is put in the proxy. Not anymore. Maximum dated, not dated, extended, not extended. Proxies are good for 11 months, period, end of story. You cannot carry a proxy over year from year. Okay. This one was signed in HB 22-1139, regulation of the use of the public rights of way. This bill was simple enough. The entirety of the bill is right there on the screen. The use of a public right of way in accordance with a local government ordinance, resolution, rule, franchise, license, charter, provision regarding the use of a public right of way. And additionally, the association shall not require that a public right of way be used in a certain manner. So here it's the association shall not regulate the use of the public right of way, meaning you cannot tow, you cannot park, or you cannot ticket, you cannot regulate the use of the public street in front of somebody's house. So it is problematic from the point of view of, in conjunction, this one is problematic mostly from the part of view of you cannot tow from a public street. If you have a tree lawn in your communities, you probably don't have the ability to regulate how that tree lawn looks anymore. You're going to have to leave that to the county or the city to enforce, because if it's in the public right of way, you have no ability to enforce against it. It's going to become really problematic. Now, we're looking at some of those things that, whether or not the municipal entity has given the association the ability to regulate certain things like the tree lawn through the PUD or through some sort of approval requirement. But the bottom line is you have and like I said, when you bring it back and when we go into some of the other bills, how it plays into this one, this bill really doesn't play well or play nicely with some others. And here we go. We've got some questions. It says, does HB 22-1040 say anything about reimbursement to the owners of any kind of supplemental amenities during the time that an amenity is closed? Example, closing pool for 5 weeks for replaster. No, that's not what it says. What it says is you cannot close it except to the minimum amount of time. So if you have to close a pool for 5 weeks for replastering, you're going to have to put on the notice or on the pool is closed. It will reopen July 4 weekend. Here's the person to contact about the closure. That's what it says. So, but like I said, to some extent, if you can sit there and during the replaster, keep the pool open, or not the pool, but the pool deck open, or if you have a hot tub that's next to it, you probably have to do that. Even unless it's some sort of, you can't guarantee the safety of the people because the pool is open without water in it. All right. Would a non-potable well be considered a common element? Yes, if it's owned by the association as part of the community, the water rights are common elements. You would have to deal with that, and you'd have to, again, you can't really close the common elements to the extent possible. HB 22-1040, how about an association with 2 hot tubs that, since build only, has both open during the ski season and then alternates between the 2 closures of one during non-ski season times? I think, Holly, that's a problem. And I think that's the type of bill that the type of situation this bill would say, no, you have to keep both the hot tubs open at all times, because hot tubs can be run in the winter. You've got 2. Those are the common elements. This bill is very broad, so I think you have to keep them both open all year, and you're just going to have to budget for it. That is the problem with this bill, as to how expansive it is and how sneakily problematic it is. Now, I don't believe for a second, and please do not jump up and down and yell and scream at this one, but I could make an argument that if you have an affirmative duty, and we go back and look at this bill, you have an affirmative duty to keep the common elements open. What if you have an owner that comes in and says, I need to be able to swim during the winter. I want you to keep your pool open year round. I think they could have a claim to require. I don't think it would go anywhere. And I think that's absolutely unreasonable, because everybody knows you close pools, outdoor pools, in the winter in Colorado. But it would be an interesting case argument, because I think somebody could come up and make that argument of you have to keep it open year round. Now, again, I don't believe that's the case. I believe it goes too far that you can, you have to apply some sort of reasonable closures. So please don't, like I said, don't jump up and down. I'm not saying you have to keep it open year round, but I think hot tubs that are meant to be run year round, I think you have to keep both those hot tubs open. Okay. The next question is, before I get on to the big bills. Okay. Regulation of the public rights of way. What about RV parking in the street? What about it? If it's a public street, you cannot touch it. You're not special that way. You can't go through this and state that, oh, RVs are different from cars. The bottom line is, you, association, have no ability to enforce RVs parked in the street. None whatsoever. Now, if somebody parks their RV in the city or county has a restriction on RV parking, you need to tell your owners to call the city and county, because you, association, are prohibited from enforcing against it. You shall not regulate the use of a public right-of-way in accordance with the local government ordinance. You can't do it. Some people have the ability to do that. They have the ability to park their RV. They have the ability to park their car. They have the ability to abandon their car. You don't have the ability to remove it. You have to call the county, have the county enforce it, or have the city enforce it. It's no longer your job. You don't get that anymore. Okay. All right. What about RVs parked in the street? HB 221139. If people don't pull their trash bins back, all right, you're getting ahead. Okay, wait. That you're not. Does this include city-owned sidewalks? Yes, sure does. If I drag my garbage cans out for collection and never put them back, you can't restrict it. You have no ability to regulate the use of the public right of way. It's garbage cans too, and city-owned sidewalks are city-owned property, or they're part of the public right of way. Are the slides going to be available? Yes, Greg, of course. We will send out the slides. They were sent this morning. Thank you so much. Altitude Community Law, you're wonderful. All right. If a pool has restrooms but did not budget to have the restrooms cleaned daily, do they still have to make the bathrooms available? Yes, you do. Again, you must protect the use of the common elements. You have an affirmative duty to keep them open. Now, again, there's some reasonableness in this. And if you're closing them at night for security purposes, fine. But if your pool is open, your restrooms are open. And I would argue that if the clubhouse is open, your restrooms better be open. And I don't know how much you can actually close the clubhouse now. I have already heard owners are coming to their management companies saying, you are now required to keep the clubhouse open 24/7 and available for my use. If I want to go read a book in the clubhouse, I should be allowed to read a book in the clubhouse. You know what? They probably have an argument. Now, again, do I still think you should adopt reasonable rules and regulations regarding use of the clubhouse? Yes. Do I still think you should close your clubhouses at night? Yes. Do I still think you should have a reservation system if you rent them out? Yes. I think all of those things stay in place. You just need to be aware of this problem with this very broad bill that says you need to protect the owner's use of the common elements. I think you have to read a reasonable amount in there or a reasonable standard in there, but I think you need to be aware of that bill, and you are going to start getting these questions. You are going to have some owner go, I should be allowed to go to the clubhouse at midnight, and you have a reasonable obligation, or you have an obligation to protect my access to it. What about supply chain problems and cannot get parts in a reasonable time? Again, if it's closed more than 72 hours, you have to put a notice on the common elements to why it's closed and when you expect it to be open. You can't manufacture a part out of thin air. There is some reasonableness here, but that's the notice requirement. If it's going to be closed, but again, you have to go out and get those parts. You have to go look for them. You're going to have to try and effort to make sure that you get them. How about keeping the clubhouse closed for reservations only? Fine. You can keep a clubhouse closed for reservations only, but you better be able to open the clubhouse for reservations, and the reservations better be readily available, which probably means you, manager, are going out to open it and close it during reservations. When does HB 221139 take effect? It takes effect August 8th, 90 days after the legislature gavelled out, which was May 11th. So you have August 8th. All of these bills are August 8th. What about dead trees in the street lawn? Well, if the street lawn is in the public right of way, call the county. You're no longer allowed to regulate it. Now, again, that you should talk to your attorney about. The public, there's the street, and then the tree lawn, they're special because you've got a lot of the approvals for the tree lawns state the association shall maintain them or the owner shall maintain them. So look at your approvals, look at your PUD, look at the subdivision improvement agreements for the community, see who's required to maintain it. Because if that's the case, you have an ordinance from the city that says it goes to the owner. So you need to look at that. That actually talk to your attorney. But on first blush, unless you have something that says from the city during the approvals, you maintain the tree lawn or you maintain this, it falls to the city or it falls to the county. And if somebody has allowed their tree lawn to die, you can sit there and say, just call the county, or you start beating on the county because they're the ones that are going to have to enforce, not you, not the association. But like I said, Sharon, make sure you talk to your attorney on that because like I said, the ODP probably says something. It shifts that to the association or it shifts it to the owner. All right. So I would say that we cannot call the city on the association's behalf. think you can call the city on the association's behalf. You probably should call the city on the association's behalf. You should also encourage every one of your owners that calls you to call the city on the association's behalf or on their own behalf and get complaints. The only way this bill goes away if the city or the county is inundated with complaints. They will go run back to the legislature and say, what the hell did you do? Parking is going to be a huge issue. Just a huge issue. Can they park boats, snow trailers, work trailers, etc. on public roads? They sure can, unless the city says the city has an ordinance against it, and then you call the city. The city or the county is going to be your enforcement mechanism for this. Or have the city or county give you some sort of permission to enforce on their behalf. The counties may get so frustrated and so fed up with them when this starts playing out, they may be happy to do so. This was some of the testimony during this bill when it was going through is there is not a single city or county that's prepared to take on the enforcement of this en masse. They're just not. It's going to be interesting to see. All right. What about parking violations and parking lots in front of condo parking lots? Those condo parking lots are condominium association property. If you're talking about a public street in front of a parking lot, that's public street. You cannot regulate it. You cannot regulate the use of the public right-of-way in accordance with local government ordinances. You can't. What about towing inoperable vehicles? We haven't gotten to that bill yet. Calm down. Hang out. We're good. Okay. What about cleaning up the street lawn areas? Sounds like these can become storage of whatever items unless the town enforces. Correct. If the town doesn't get on it, you're going to have problems. You cannot, again, you're prohibited from regulating the use of the public right-of-way. That's the bill says. Okay. Let's get on to the next one. Question. Okay. So it says pending signature. That's no longer true. Governor pulled it last week or earlier this week. Towing. It puts a number of restrictions on towing companies. It becomes harder to remove vehicles from a common area. The only real ability you have is if a vehicle, to do it right away, is if a vehicle is parked in a limited common element parking lot assigned to another owner. If a vehicle is parked in assignment or in a fire lane, you can tow right away. Other than that, it requires a number of notices. It requires at least 2 notices as to why it is parked wrong, and that continue to park that way will result in it being removed. The towing inoperable vehicles, again, you're going to have to publish a couple notices on it. You're going to have to make sure the tow company has proper signage. You're going to have to make sure that everything is done in accordance with the new act, which, like I said, requires multiple warnings, multiple notices, requires the tow company to have signs that has the international signature, the international symbol of a tow, and the parking lot, it must be facing the street from the parking lot. A lot of these are on the tow companies. So your tow companies are going to have to be up to speed with this, and they're really going to have to know how to address this and make sure that your warning stickers are correct and compliant. And you guys are going to have to be able to make sure that you are capable of removing vehicles from the community. Now, it should be noted that this towing bill does not mention booting at all. So if you guys would rather boot, go ahead and boot in accordance with your rules. But to tow, to actually physically pick a car up and remove it, it requires at least 2 notices, 24-hour notice, and stickering. Lots of stickering. You can only remove it immediately from a fire lane, or if it's parked on private property, common element parking area, or a limited common element parking spot. So towing inoperable vehicles, unless it is parked in somebody's parking space or in a fire lane, multiple notices. But again, it cannot be on the public right of way. You cannot tow from the public right of way. Should pool restrooms be open the pool season prior to August 8th? I have a board that wants to keep the restrooms closed. Nope. If the restrooms are common elements, you cannot keep them closed. Got to open them up. And like I said, reasonable access. I think that if your restrooms are, if you can access your restrooms without going through the pool area, yeah, you probably have to keep them open during the day. You can close them for security purposes. I think you probably have to keep them open 24/7 year round. Again, this one is going to be, I'll tell you after a court tells us exactly what it means, but the plain language of that bill, you have an obligation to protect them all the time. Okay, let me see. Should pool restrooms be open this season? Yes. Prior to August 8th. Yep. can an HOA enforce? I'm not sure what you're talking about in HOA enforce. Oh, did we determine responsibility on street lawns in front of homes? We sort of did. You have to look at your PUD. You got to make sure that the association has the ability to enforce on the tree lawn, and that'll be in your PUD or your subdivision improvement agreement or your official development plan. You're just going to have to go make sure that you look at it. Look at all those documents, see what the association's rights are. In front of dumpsters, I'm assuming that's parking in front of dumpsters. I would argue that that's parked in a fire lane and you can remove it instantly or immediately. But again, you have to have all the signage in place. How far apart do the notices have to be for towing? At least 24 hours. Does the towing law apply to LCE assigned spaces? Yes, it does, but you can tow immediately from an LCE assigned space. How about towing for garage cleanings or road work? Again, if it's road work on the public right of way, no. If it is road work in your community on a private street and you have published notice in the community that there's going to be road work all over and that you have said when and why and how, and somebody parks the street and you sticker it the day before, you can remove the day of the road work. But make sure you start stickering early. Make sure you are closing the parking on the road or the parking lot early. So let's say if your work, it doesn't start till Wednesday, you start stickering on Monday. And you've got Monday and Tuesday stickering so you can remove it on Wednesday. Same question. What about towing for alley maintenance that has been noticed to individual homeowners? Again, exactly what I just said. Start the notices early. Say close it down early, even though work doesn't start on a Wednesday or until Wednesday. I would close it Monday, so that gives you Monday and Tuesday to sticker and then remove on Wednesday. What if parked in front of a trash container and cannot empty? Again, I think you can remove that instantly because it's impeding from your duty and it shouldn't be parked there. Can we pass the extra pickup cast to the violator? If you can't pick up because somebody's parked that way, yes, that's negligent on their behalf if you know who that owner is. Remember, you also have to know who that owner is. What the best method of obtaining PO is, aren't they always recorded or readily available? Yes, they are recorded. They should be readily available. You should also, if you need to, you can just do a CORA request, which is a Colorado Open Records Act request, to get them from the county. You should be able to get them. If road work is going to be done, can we relocate the vehicles but not actually tow off the property? Yes, you can. You're just going to have to get a tow company to know it. For towing, if doing an asphalt project, okay, I'm seeing a theme here, my friends, that it's if you have a common element parking and you're going to do asphalt repair, start early, do the notices. You can move cars to the air, but the bill doesn't prohibit moving it from space to space. It's if it goes to an impound lot. You're just going to have to tell the owner where it went. And again, you've got to get a tow company willing to come out to do it because remember, this bill is huge. Couple of paragraphs apply to associations. The bill itself is huge about documenting the tow, documenting the condition of the vehicle before it's touched, and making sure there are a lot of obligations on the tow company which don't impact you, but they are required to comply. The tow company is required. But yes, I think you can get up and move it to another part of the parking lot if it's not moved. You can charge the cost of it. But again, the notice here, or the theme here is notice, notice, notice. Notice owners early. Notice them often. Tell them they can't come back. Close the area early to make sure that you have time for all the notices if you're going to tow and remove. I don't know if a tow company will come up and pick it up and just move it to another place in your community because they're going to want the money for the tow job and they're going to want to be able to take the vehicle off site unless you're paying for it right up front. So things to think about as we get through this tow bill. It's all sorts of fun. All right. All right, here's the big ones. 1137. Let's talk 1137 for a minute. This bill is huge. This bill materially impacts the way you do business. This bill alone requires you to update at least 3 of your good governance policies. Your collection policy, your covenant enforcement policy, and your conduct and meeting policy all need to be updated, replaced, redone because of the mandates of this bill. This bill was signed last week. This bill will become effective August 8th. So let's talk about this bill. It is titled the Board Accountability Transparency Bill. I find very little in it that is for board accountability and transparency. But hey, It really involves collections, foreclosures, and covenant enforcement. To start off, some of the major highlights. Requires a majority of board vote in a closed hearing to refer an account to an attorney or collection agency. It's similar to how you were doing foreclosures. Adopt a resolution to turn it in, take a vote. The big difference, this must now be in an executive session, a closed door meeting. The intent is that you are not parading around delinquent owners' units when referring them to a collection agency. So you now have to have a meeting of your board to go over these matters. Individually, you cannot do it in bulk. Everybody more than 6 months delinquent gets referred to the attorney. Nope, you have to do it by individual unit number. Owners are entitled to know how the vote was cast. Not necessarily who, but they get to know, was it unanimous? Was it 3-2? Was it 2-1? Was it, they have a right to ask for that. There you go. See, I'm psychic. It's like I know this. The owner may request to receive the results of the vote taken at the meeting. Okay, you now have a notice requirement. Prior, this is before you send the associate, before you can take any action on a delinquent account. The first step, owner goes delinquent. The very first step you must do, the notice of the delinquency must be sent by certified mail, return receipt requested to the owner. Second, it must be physically posted at the owner's unit. Okay, 2 notice requirements right up front. This is before you can do anything. The owner goes delinquent on day 1. Your policy says they become delinquent on day 15. You must, at that point, send a certified letter. It's the same letter as you used to send with, it's your same delinquency letter. You just now have to send it by certified mail, return receipt requested. You have to keep the certified mail. You have to keep the tracking numbers. You have to keep a copy of the letter. Then, once you do that, you got to go running out and you got to go put it on their door. Okay? Then, when you get back, you also have to send an email, a text, or mail it first class. So, practice pointer, if you're sending it by certified mail, I'm going to tell you to send it by regular US mail anyway. Might as well knock both of those out at the same time. And then take the letter and run it out to the door real quick. Maybe do it at night and do it. Look out for Ring doorbells. They're going to be there. You're going to get it. It's a mandated statute, guys. You have to do it. You have to go put it on the unit door. Okay. Also, if the owner gets it and looks at it and says, nice notice, next time I want it in Chinese, you have to now take that back out and have the letter translated in Chinese, and all your future notices are going to go in English and Chinese. Okay? The owner can also request that you send it to a person or a second person, or a representative. You now have to send the exact same notices you send to the owner to the second person if they tell you who to do it to. Okay? So it's their agent, it's their property manager, or if I'm living in my house, I'm going to tell you to send it to Mike Tyson. I want all my notices to go to Mike Tyson as my representative too. Okay? I have that right. You now have to do it. Now, of course, I have to give you Mike's address, but you have to do it. You don't get out of that now. All right, guys, I'll catch up on the question in just a few seconds. All right, here we go. We got more. This is a big, big bill. Also, on a monthly basis, the association must send to the owners whose accounts are delinquent an itemized list of all the assessments, fines, fees, and charges owed. So essentially, you are going to send the notice, you're going to send the letter, and then on a monthly basis thereafter, you tell them how the account's being serviced. Is it growing? Is it done? How is it now realized? How much have they paid? Where's it being applied? Oh, there's also an application of payments in this bill too, my friends. So where's it going? How's it applied? What are you doing? All that fun stuff. You have to email that to them on a monthly basis, or you have to mail it on a monthly basis. So you now have a new requirement of telling them monthly the status of their account. And you can't charge a fee for that. All right. Interest rate. No matter what your declaration says, the interest rate is now capped at 8%. Okay? All of your collection policies need to reflect that. And then when you hit August 8th, you have to adjust all of your systems to reduce it down to 8%. Okay? Very important you do this. It's going to be very interesting to find out how the courts interpret that piece of the bill. But the bottom line is, effective August 8th, 8% maximum interest. Grace period. Annual assessments, installments must be paid within 15 days of the due date, so your first notice can go out absolutely no earlier than 15 days. If monthly, no legal action may be commenced unless the owner has failed to pay at least 3 installments of their 18-month payment plan. Not kidding, 18-month payment plan. All right? And the payment plan is on just the delinquency. You can require they keep current on all their monthly assessments, but when you get the delinquency, you have to say, okay, owner, you have 18 months to pay this. Here's how we calculate it out, and they can respond to you. And wait, I'm sure the next one is the designated owner. They can tell you that, who to send it to. Application of payments. You must apply payments first to assessments owed and then to fines, fees, and other charges. You cannot start the back way. It goes first principle. What they're trying to do is make it much harder to collect late fees, penalties, and interest because courts hate the situation if you are going after just late fees, penalties, and interest. They only want you going after the balance. And if you apply all of it to the balance, it makes it much harder to collect all the other stuff. All right. This bill allows for concurrent jurisdiction for small claims court disputes. So it means to encourage the use of small claims court. I don't recommend it. It's concurrent jurisdiction. It is not singular jurisdiction. You don't have to file in small claims court, and I would expect you to use, quite frankly, your attorney anyway, because there's a rule of civil procedure that says any corporate entity must be represented by an attorney in all court proceedings. So it really doesn't get you out of that. I know that was the intent, but it doesn't get you out of it. Okay. More on this fun bill. Oh, like I said, it keeps going and going and going. All right. Payment plans. Changed from required payment plans of at least 6 months of equal monthly installments to at least 18 months. It authorizes the owner to choose their payment plan. It's like choose your own adventure. You get to choose your own payment plan as long as it's at least $25. And you cannot pursue legal action unless an owner, as I mentioned before, after entering into the payment plan, you have failed to pay at least 3 of the monthly installments within 15 days of the due date. So you are stuck there. Unless they fail to pay 3 payments on an 18-month payment plan, you cannot sue. You have to let them keep going on. And like I said, the debtor gets to choose their own adventure. It has to be at least $25. Okay. And like I said, this is the bill that keeps on giving. All right. Fines and violations. There is the covenant enforcement piece. You are no longer authorized to fine on per day basis. You also cannot foreclose on balances that are just for fines. If an owner is current with their assessments, you cannot foreclose just on fines, interest, late fees, attorney fees, penalties, only on assessments. If a violation threatens public safety, health, or welfare, you must give written notice of the violation within 70, and that notice must contain a 72-hour cure period, and only then may you fine after 72 hours. You can also fine every other day and take legal action. Now, here's my problem with this is if there's something on a property that has life, health, safety connotations that or will impact life, health, safety, first, you have to give them 72 hours. So I hope it's really not that bad a life, health, safety issue because they get 3 days to cure it. And secondly, why would you fine? I think that makes absolutely no sense. I think that goes straight to a lawsuit because if it really is a life, health, safety issue, you're going to have to go straight to a lawsuit. Now, that being said, if a violation does not threaten the public safety, health, or welfare, you have to give written notice by certified mail with confirmation receipt of the violation with 2 30-day cure periods. Then you may fine. Only after the 30 days. So They go 30 days. If they don't cure it, you can start fining, and they get another 30 days. Total fines may not exceed $500. So going back to your parking problem, okay, your RVs. Let's take your RV off the public right away. Okay, I'm going to pull my trailer, my beautiful new trailer. I'm going to pull it onto my front lawn, and I'm going to park it there. It's not on the public right away, so you can enforce. You have to give me 30-day notice. Great. You gave me 30 days notice. I move it. I bring it back on day 32. You have to start over because I get to tell you, wait, this next slide. Once cured, the association must notify the owner that the outstanding fine balance and that no further fines for violations will be issued. So if you can't find me in the first 30 days and I move it for a day and bring it back, and I send you a picture that says I moved it, I get to park my trailer there 30 more days. Go, David. Fine policy must specify the intervals upon which fines may be levied for continuing violations. Hearings, disciplinary hearings are considered unwarranted invasions of privacy and may now be conducted in executive session. Fun stuff. I promise. I'll come back. I'll go to the top of this big list. Board members, employees of the management company, and employees of law firms representing the association or their immediate family members cannot purchase a foreclosed unit. My brother is an investor. He buys foreclosed units. I now have to make sure he is not buying any unit from an association represented by this office. If the association violates any foreclosure laws, the owner may seek punitive damages up to $25,000 plus court costs and attorney's fees. Fun stuff. All right, let's go back to this. Let's go to the questions. All right, here we go. Where do we go? Because these, oh my God. Okay. Do both use both around? Okay. Someone's going to get shot. Not smart. No kidding. Okay. Okay. What if the unit? Let me see. Here we go. Same. How come a manager is supposed to go into the? Okay. All right. What if only the board members are present, or does it have to be an official executive? Okay. Here we go. Starting with what if only the board members are present, or does it have to be an official executive session? Well, an official executive session is only the board members present. So as long as you have a quorum of the board, they can take action. But it does have to be in an executive session. You start with the executive session by a general statement of what you're going to do. So your new executive session topic will be to discuss delinquencies and referrals to collection agency or referrals for a collection. That is your new topic for your executive session. And you go and kick all your owners out and you go do it. Is it not trespassing to go onto a homeowner's property? It's not, unless there's a big no trespassing sign, but you probably have an easement to go onto the property to perform the association's function, and you're going to have to go do it. Put it on the front door. 221137, can an owner account be billed for delivery expenses? Yes, you can still bill those. Same. How are community managers supposed to go onto private property? Again, you probably have an easement, but the bottom line is the statute now gives you authority to go onto it and post notice. Not saying it's wise. I didn't write the bill, but that is the requirement. You have to go post it. Now, again, if it's condominiums, it's very easy. You just go do it, but you have to go up to the front door. Post it on the unit. Now, I think with the single family community, it says posted on the unit. So if they have a mailbox or if they have something that is down at the bottom, I say the door because I'm referring to condominiums. I actually think quite possibly if you have a stake and a little sign, a little piece of wood, a stake, and you just staple it to the stake, and then you can go pound it in the front lawn, that will probably work as you think it through because it says posted on the unit. Kiowa, the Colorado Communist Ownership Act, says the unit and the lot are one and the same, that it's the same word. So if you're posting it on the unit, you could probably, like I said, get a little placard, a little metal stake, just go tap it into the front thing, and then go get your stake back the next day. Actually, it'll probably wind up in somebody's windshield, but hey, you can go get it out of the person's windshield when you're done with it. What if the unit is, okay, okay. What if the unit is known to have a renter and you know the owner doesn't live there? It doesn't matter, doesn't care. The bill says posted on the unit. Notice still required to be posted? Yes. If so, isn't there a confidentiality violation? No. The statute actually says you are not a debt collector. Management companies are not debt collection companies. The statute gives you that protection. Go post the notice. It's what you're required to do. What if the owner does not sign for the notice? Does not matter. You just have to prove you sent it, which includes, like I said, hold on to those tracking numbers. What if they live at an offsite address out of state? Again, doesn't matter. Post it at the unit. Can this special executive session be called so board members can vote via email, or does it have to be in-person board meeting? Virtual is okay. It has to be a meeting. Don't do this by email. Don't do it by action outside of a meeting. Do it at the meeting. Also, does the notice have to be posted on the property, not the owner's address? If, for example, the owner lives at the unit, at the property that is delinquent. You do not send, you're sending it out via certified mail to the address that he gave you. You post it at the property. Remember, the problem with this bill, or the problem the legislature was trying to solve, was the story out of the Springs of a lady that had her house foreclosed upon, and she was blind and deaf, and they dropped the papers at the property, and she never saw them because they wound up onto the mat. That's what they're trying to get around. They want you to post it at the property. There's also a appellate case that just came out of the Colorado Court of Appeals that it was a foreclosure matter, and the court impugned or implied there was an additional duty to an association to act in good faith. And essentially what it said is publishing it in a paper nobody reads is not good enough, even though that's what the statute says. We get it. We know this. The court said we get it. We know it. But you've got a duty of good faith, so we want you to post it at the property. You have to now go post at the property, my friends. Can't get around it. Post the notice that you sent in the mail at the property. End of story, period. Post at property. Okay. How long does it say the post the physical notice? Doesn't say. You just have to do it. Okay. That's just go do it. Take a picture of it. You have to document that you did it. Because if you go to court, remember, we're going to have to include that as part of our pleadings. And here's the notice, and here's the picture we did it. And all of this. All letters posted at the door, just the referral to the collection letter. Right. All letters posted at the door or just the referral to the collection letter. No, you're right. No, actually, just your collection letters. And it's just that first one. Yeah, first step, posting in the property. All right. Someone's going to get shot, not smart. Can't disagree. Can't argue with that. But again, that's what the legislature wanted. So that's what you got. Do you recommend sending a letter to both the homeowner and their renter? No, just the homeowner and the homeowner's designated representative. So if the homeowner tells you where to send it and says, I want you to copy Mike Tyson, and I give you Mike's address, you have to do that. But you don't have to copy the renter. However, you have to post it at the property so the renter's going to know. All right. How about posting on vacant lots that are delinquent? Again, I think what you do is you get your little stake and a little piece of wood and just post it, nail it to the post and put it on the property. Or go get a couple of, like I said, little yard signs and put it in the yard and throw it on the yard sign. Does this apply to any delinquency notice? Or so have to send 3 notices before going to collections? Again, get your mind out of the 3 notices before you go to collections. All right? You have the very first step. Owner goes delinquent. Certified letter, post at property, U.S. mail. Those are your 3 things, or text or email. That's your first letter. Okay? Then you have to go through all the other stuff. Monthly notices, how their account's doing, offer the payment plan, get them into the payment plan, do all those fun things. But do all this stuff first. Okay. How does posting notices on the doors of renters comply with Fair Debt Collection Practices Act? The statute specifically says you, management company, are not a debt collector pursuant to the act, and therefore it doesn't. They tried to carve that out. I guarantee somebody is going to sue over it, and we're going to find out if the federal legislation, what is referred to as occupies the field, and if this violates federal law. Somebody's going to sue, and we're going to have to get that question answered. It'll be really interesting. Does notice posted on the door need to be in or out of envelopes? It doesn't say. It just says posted on the door. I would put it in an envelope. Best practice. Put it in an envelope, paste it, post it, staple it, do whatever. Okay. Are there multiple owners? Do they all need notice? No. You send it to the owner of record that you do business with that has been designated the representative of the owner. And then, like I said, turn around, and if they tell you to send it to everybody else, you have to send it to everybody else. Let's send second copy to Governor Polis's home as representatives. Ooh, I like that more than Mike Tyson. Damn it. Thank you. That is a great idea. I think all the owners should tell us that Governor Polis is a second agent. Send it to Governor Polis's office. That is a great idea. I like that so much more. Okay, if they live off property, where does the notice get physically posted? The property. Guys, property, physical. The one in your community that you're seeking that is delinquent. That's where it goes. Can we charge the delinquent owner the notice expense? Yes. Physical posting labor? Yes. Attorney's fees? Not attorney's fees until we're further down the road. But all the other stuff, yes. What about late fees? What about them? 8%. Lisa, I'm sorry. You'll be missed. We love you. I hope you don't. All right. Do we have to change prior interest rates if more than 8%? Yes, but you don't have to do it until August. But yes, 8%, whatever, no, regardless of what's in your deck, 8%. It's capped by statute now. Again, go back to what happened. They felt that you never get out of debt when you're charging 21% interest and attorney's fees and all this other fun stuff. Moving forward, 8%. I also think come August 8th, if you have current accounts that are being serviced, interest rates have to go down. Any delinquency as of August 8th, interest rate is now 8%. If they are already on 6-month payment plan, do we have to revert to an 18 months after August 8th? I would argue, yes, you do. You must offer any delinquency effective August 8th, gets 18 months to pay. Now, hopefully, since that is 4 months from now, 3 months from now, you'll get most of them wrapped up. If not, we're going to have to do, it's kind of a start over. I would argue, yes, you do. Given the new challenges to collections, do you anticipate associations going away from monthly payment structure to an annual lump sum? I think that's a great idea. And actually, Greg, most associations do adopt an annual budget. They just allow it to be paid annually. I think it would be a wide departure from norm, but I think you could do it, yes. If associations want to say, look, January 1st, all assessments are due, and you just have this fight all up at once. But remember, the problem you have with this bill is that if somebody goes delinquent mid-year, then all of a sudden you're impacting 3 assessment years with an 18-month payment plan. You guys are going to have to run cash flow analyses to find out how much your assessments actually need to be on a per annual basis, since you are now divvying up a 12-month assessment into 18 months. How's that going to impact your budget? Inquiring minds want to know. Most of our HOA is second homeowners and are not on site. Posting on the door is ridiculous, and safety issues. It's an invitation for robbery. Mary, you're preaching to the choir. I don't care. Post it on the property. Take a picture. All right. It's not that I don't care. I love you. I care very much. But the legislature didn't care. Governor Polis didn't care. Go put them on the doors. Has altitude law considered composing a flow chart for managers to use as a tool to navigate best practices or create an SOP to follow? Of course we have. And we're getting them to you in your policies. You need 3 new policies. This collection policy is enormous now, but it will contain the flow chart. It goes through the process. Are the payment plan requirements for 18 months begins in September, August, or now immediately? August. No, Diana, it's August. So continue doing everything you're doing until August 8th, and then everything changes. For payment plans, if the owner pays only $25, will they owe the balance at the end of 18 months, or do they get another payment plan? Mike, that is a great question. I wish I had an answer for you. And more importantly, what if they pay 17 payments exactly on time and don't make the 18th, paying only $25 a month, and you can't refer them to collections unless they default on 3 payments? If anybody has an answer to that one, please let me know. I think we're going to sue on it. We're going to get an answer from a court. because it says an 18-month payment plan, and if they're delinquent at the end of that payment plan, you can move forward. So yes, it acts as a balloon payment. They have to pay it all at the end. If they don't pay it all at the end, can you pursue it? Yes, you can. I think there's going to have to be some level of common sense in that, though, because if you just have this lump sum and you say do it, and then you push it into foreclosure or you push it into collection and then it's delayed even more, it could become problematic. So I think it's bottom line on that, Mike, it's going to be a case-by-case basis. You'll have to look at it and decide what's in the best interest of the association. For the payment plans, does it have to be 3 consecutive months of? No, just any 3 months during the 18. So it's not 3 consecutive. It is 3 months, any 3 payments. Can the cost of certified mail be charged to the owner? Yes. Total amount of fines may not exceed $500. Yes. The life of the property, as long as that owner owns the property, per violation. Okay. So the $500 is per violation. Let's go back to me parking. Let's go back to my jackassery and I park my trailer on my lot, right? And I gave you the scenario of I move it off the lot every 30 days. I take a picture. The violation is deemed cured when I provide you photographic evidence that it's cured, that you cannot apply any more fines to it. So on day 29, I take a picture. Day 30, I put it right back. That's a new violation. I can violate your declaration. I can violate your rules by parking my trailer on my front yard for an entire year without doing it that way. Okay? Because I've cured. Every time I go cure, that's a unique violation. Let's say I go the other route because my truck broke down and I've got my broken down truck sitting on the front street, which is public right away, and you can't touch it. So I got my broke ass truck sitting in front of my beautiful RV sitting on my lot, and I can't move my RV. Okay? You send me a violation. I pay the $500 and I store it there. As long as I do not cure it, you cannot touch me. I bought that parking space for $500. Thank you. I'll see you when I move out. What this bill does is it encourages lawsuits. You are now going to have to sue me over that RV infraction because I'm not going to move it voluntarily. I paid you my $500 fine. I don't care now. I bought the spot. Leave me alone. It's cheaper than the RV storage. You're going to have to sue. If somebody thought this was going to calm down lawsuits, if somebody thought this was going to avoid lawsuits, they were sadly mistaken. It encourages lawsuits. The mantra at the legislative session was, oh, I would have cured it had I only known. My guess is that's not true. My guess is you're going to get people like me that are going to tell you, sue me, and you're going to have to make a decision. Okay, total amounts $500 for the life of the property. No, it's per violation. So let's say I have 2 violations. You can fine me up to $500 per violation. What if a covenant enforcement policy states that to be in compliance, the violation cannot reoccur in 6 months or something similar? I think that can be in the covenant enforcement policy, but if I cure it every time, you can't touch me. I think it is, you're going to have to sue to get a court to say, nice try, jerk, move the RV. And again, I always love using myself, and I refer to myself this way because I'm just the type of cantankerous person that would do it. I like to play. And I think you're going to get owners that like to play. And I think you're going to have to do that. And then just pay the $500 cheap storage. Yeah, I agree. All right. Is there size and or color we need to use to post it? No. It doesn't say it. It just says post it on the door. So really, again, print your letter off. The same one you sent by certified mail. Just print it off, put it in an envelope, post it on the door. Or post it on a sticker or whatever you do. Can we get the sticker for the parking violations to post notice on the front door? Oh, I like it. Yes. Use parking stickers that can't be removed easily. Post it on the door. Nicely done, Adam. All right. Do process servers post notice like these? I guarantee somebody's going to come up and post notice like these. $20, go post them, do your entire community? Yes, somebody's going to do it. Can you hire somebody to post notices? Yes, you can. And front porches, say single-family home or private property, how do deliveries sidestep this? Again, it's the same thing. Well, when Amazon makes a delivery, when FedEx makes a delivery, you have invited them on. I filled out the form. I said, deliver it to the soft property. They are now my guest and invitee of the owner. Getting to this, you have to go post it. Like I said, you don't have to go onto the property. I think, again, the more I think about this, since it says the lot, you can just post it on a sticker or post it on a little thing right at the end, right at the driveway. Just make sure you don't damage the irrigation system. Can we use third parties to post notices? Yes. Do you have to send every letter certified mail? No, not every letter, but you do have to send the delinquency letters and you do have to send the violation letters. Will we need proof that it was posted at the property? Yes. Make sure you're taking pictures of it. Collections, give the first notice. What was required time before you can send the second notice? The second notice, still the required statutory letter, 30 days to enter into a payment plan. But if they do not, contact the office to set up a payment plan. Okay, this is correct. Yeah, it's about right. Like I said, follow the collection policy that you are now doing. You have to 15 days to give the first notice. They have time to respond. You're gonna have to go through this process, and it's like I said, we've created the timeline. It's in your policy. Once you get your new policy, you're just gonna have to go through and dissect it that way. Tape envelope with notice to the door, or a piece of paper with tape on the door. All neighbors can see this. Yes. Yes. Post the envelope. Document the date and time. Yes. You have to. Send yourself a picture. Do declarations need to be amended if the delinquency provision is 8% or more? No. You don't have to amend your declaration. You do have to amend your policy. You must. And then your declaration is amended by statute. So do you actually have to amend your declaration? No. It's done by statute anyway. Okay. Aren't there legal consequences if a tenant resident opens a certified letter to the owner? What do you care? It's as long as you are complying with the statute. What do you care? Isn't it a federal offense to open other people's mail? No. Actually, that's a misnomer. What is the federal offense is messing with the mails while they're in transit. If you send a certified letter, you put it into transit. If somebody steals that letter while it's in transit, yes, that is a federal offense. And if you want the history of that, I can go to the history of that. It's actually really cool. But the bottom line is, once it is in the mailbox, it is no longer in transit. And while it is still an offense, it's not necessarily a federal offense. And you cannot control what happens if the tenant gets mail at the unit and you send it to the unit. But again, you're only posting it at the unit. You're sending it certified to wherever the address the owner gave you. Is there a resource to have letters translated into other languages? That's a really good question. And yes, there's going to be a resource, and you're going to be able to not charge that to the owner. That is now an association expense. And getting into that fun thing, guess what? I'm going to tell you, because I'm that guy. I want a new language every week. No, there are services, I am sure, you're going to have to get it translated. I do not think Google Translates is sufficient. Sorry. I think you're going to have to go find somebody to translate the letters. Does this apply to timeshares? Sure does. Sure does. Your timeshares were not exempted out of this. Can you have board members post notice? Yes. Anybody can post notice. If you want to pay me, I'll go post your notice. What if the condo unit is only accessible via direct elevator that the management company does not have access to? Why would you not have access to it? Board members are going to have to do it. Somebody's going to have to get in there to post notice at the unit. I don't think posting it in the elevator, I don't think posting it someplace on the first floor works. I think you have to do it. Do we need to change the declaration? No. To reflect the 8%. Can we still, but don't get me wrong, guys. If your declarations are old and out of date and pure, you should probably update them anyway, but not just for this one thing. It's deemed changed by statute, so don't worry about it. Just adopt the policy. Can we still accelerate payments for delinquent accounts? Yes. They get the payment plan? Yes. The assessments through the end of the year? Yeah, you can. Notices should all go to owners, not just one. Okay, there you go. Is there a limit to the charge amount of posting notice at the property? Yeah, it's going to have to be reasonable. You can't go charge $3,000 to post it on the property. I think it has to be a reasonable charge. Process server rate should be cheaper than process servers because they're not actually trying to go get somebody. They're just putting it on the door. Will acceleration still be an option? Yeah, I think so. Will HOAs be required to sell previously purchased foreclosed? No. That again, no. They just can't. And the association can buy the foreclosed unit. Board members can't. Attorneys can't. Family members can't. Associations still can. Now, then, here's the rib bro. Once the association owns it, I would be really hesitant then to sell it to an owner or a board member or a board member's family. I wouldn't. I would make sure that everybody is excluded from the sale of that when you put it on the market. Weed and lawn violation still 30 days? Yep. With 60 days to cure. So you may not be able to cure during a summer. If a process server is used to post delinquent notices, is the delinquent owner on the hook for the cost of the process server? Yes, you can. But again, I would not use a process server unless they reduce their rates. It has to be reasonable. What about habitual offenders? What about them? You just described me. Some HOAs have language about habitual offenders. Yep. But if they cure and violate again, they can probably evade it. And you're going to have to sue because you're going to keep sending notices, which you can't charge for. And they're going to have 30 days to cure. And then they cure and take a picture of it. They can play the game all summer. They can play the game all year. It's going to be a problem for you guys. It makes it really hard to enforce. I'm not lying. So if an owner goes out into an 18-month agreement, then the new year arrives, and then he defaults and goes into another 18-month agreement, this could cause major issues for HOAs. Yep, sure could. Can we have the person posting the notice on the door sign a checklist with every unit checked off with the affidavit at the bottom saying, I mean, yes, but why not just take a picture when he does it, Mike? It's better. It's easier. Yeah, you can do it, but then you're challenging the person, the affidavit, and you are just adding extra layers to it. I would just take the picture of the door, kind of like Amazon does. Does any of this apply to metro districts? Again, good question. The legal answer is no. The best practices answer is yes. Courts, when you have a metro district enforcing covenants, I think they are going to look for the same reasonable standard that is set forth in Kiowa, and I would just be prepared to do it. If you represent a metro district and they are enforcing covenants, I would expect to be applied to the exact same standard, and you might as well just get used to it. But legally, no. But I don't want to make that argument. All right, you mentioned 3 policies need to be changed. Collection enforcement, what's third? Conduct a meeting. You now must have a new conduct a meeting saying you specifically go into an executive session for delinquencies and enforcement, discussions on delinquencies and enforcement. You need the 3. Can we bill back the party for services posting? Yes. Is there a cap on late fees? Yes, 8%. I'd like to, okay, does the owner have to be able to read the language being requested? No, they don't. They just have to request it in that language. That's not, the statute just says I can notify you of a language I prefer to receive communications in, and you still must send it in that language and English. No, I don't need to read the language. And I want you to send it to me in Klingon. Good. All right. High-end condos often have private elevators. Yes, I understand. If the private elevators go to a private floor, you could probably post it in the elevator. Greg, that's going to be, again, you're going to have to, that's going to be an interesting question, where to post. Now, if you have high-end condos with private elevators, boy, I hope you don't have delinquency problems. Could be wrong. If an owner is designated contact, send to both or just the designated contact? Both. Both must receive the exact same notices. I'm going to skip that next one. Sorry if someone already asked, how do we handle out-of-state owners? Post at the unit. No, you post at the unit. You don't post at their real address. You are required to send the certified mail to that address out of state. Post at the unit. 2 separate and unique post or requirements. Certified mail out of state, post at unit. Certified mail, post at unit. Okay. For owners currently in collection, does the payment plan term change? I don't think so, but it wouldn't be a bad idea to offer it. because it says any delinquency, you must offer an 18-month payment plan effective August 8th. So again, it's technically no, but I'd be prepared to offer it. If the management company and or the association is following these statutes, does the association still need to get the policies changed? Yes, they must appear in your policies. That's where they go. That's where you have to put them. Because remember, the standard is not to say, go read the statute, owner. It's to say, here's my policy. You must have the policy. Must. Sounds like managers need to update their life insurance. We're definitely okay. Hazardous pay, yes. Okay. With that being all the questions, I got a little bit more. No. Okay. You said that there's a cap on late fees, 8%, so we cannot charge $25 late fee plus 8%. It's 8% on the interest. There is no cap on late fees, but guys, the courts are looking at this. The intent is not to pile up these late fees. So be real careful on that. All right, I'm moving on. I'll come back to all questions after Mike's in a minute. All right, the reserve fund bill, it was vetoed. So the next 5 slides are on reserve funds, but I'm still going to go over it because Governor Polis in his veto said, I liked some of the parts of this bill, but do not believe that raising the cost of living in a community association with all the other expenses owners are experiencing now and all the other inflation and all gas prices, raising costs of living in an association is not the best way to proceed right now, but I like some other stuff in this bill. And then he signed 1137. I don't get it, but that's okay. He did veto the reserve study bill. So you no longer have to have mandatory reserve studies. You no longer have to update them every 30 years. You no longer have to get a level 1 every 30 years and a level 2 or 3 every 5. But he did like the getting estimates of revenue, operating expenses of the association, giving information as to whether the budget has been prepared on a cash or tax basis. He did like total reserve funds the association has to date, and he did like the estimated reserve funds the association may require for major shared components. He encouraged the legislature to revisit those topics next year. Expect a new reserve fund bill to come out next year. He just didn't like what I had been preaching as you must be fully funded in your reserve study component. That's where he stopped. That's where he drew the line. So, again, look for a bill next year that goes into the amount of the association anticipates that it will need for a year-over-year basis. He likes the transparency piece. He wanted that piece, but he didn't like the funding requirements. Okay? Reserve funds can still be subject to veto by the unit owners and all the other fun stuff. So this was vetoed, but again, expect it back next year. And then he also liked in reliance upon a qualified investment advisor, you can invest no more than 25% of your reserves in other instruments. So we can go back and start addressing all sorts of questions. Okay, here we go. If good homeowners get frustrated with the enforcement changes, who can we refer to them to for changes or complaints? Governor Polis, yes. I mean, my friends, you should absolutely start the barrage of calls to the counties, to your local representative. Why did you allow this bill to be signed? These are the problems we're having. We are 2 months in, and this is what we are experiencing. This is an absolute requirement. You must do all this until you're told otherwise. So you really do need to make sure that you are following this bill. And then, yes, refer complaints to the government. They're the ones that did it. Okay. Let me see. Managers concerned about their safety might check out their management agreements to see if activities are exempted. Yeah. But somebody's going to have to do it, but you can absolutely look at your management company contract and see what's going on with that. Since the payment application goes into assessments first, if all assessments are paid and the decks say assessments are a lien on the property, can you confirm that a lien cannot be placed or collected upon for late fees? You can still lien, but you cannot foreclose that lien if all it is for is late fees, penalties, interest, attorney's fees. You cannot foreclose on that. You can still collect them, but then you have to go justify in front of a judge why you're collecting late fees, penalties, interest, and attorney's fees. It's still legal debt. You just can't, you just have to justify it. It was intended to make it harder. It absolutely was. Even if the, okay, let me see, even if the reserves bill died, arguably the requirement of common elements to be available causes the same money issue as concerned with the HOA's being fully funded. You're absolutely correct. You have to protect the use of the common elements. How's that going to be done if you're not fully funding your reserve accounts? Can't close your common elements for convenience anymore. Yeah, you're going to have to budget differently. This is a lot of information. Your examples are wonderful. Yes, it is taped, so you can get it. You can go over it again. You can listen to it again and again and again. You know, I've started listening to my nightly meditations and nightly stories on the Calm app. You know, put this one on YouTube. Play it in the background. I guarantee I'll give you nightmares at night. It is taped. It is on YouTube. You can absolutely listen to it. It's yes. Okay. Yes, you'll be uploaded. You're okay. There we go. Not required, but HOA is adopting policy on who to contact for violations. The municipality government must be addressed. You know, again, this is just something that you can absolutely, when an owner calls to complain about the RV parked on my lot, tell them to call the government. When they start to call about the broken down, abandoned vehicle on the street, call the government. When the community is invaded by people living in their RVs, call the government. You got to call the county. You really got to hammer them, because, like I said, what'll probably happen is they will, by resolution, say, "Okay, you handle it," because they are not equipped to handle it. You're going to have to now work with your communities, work with your governmental entities, work with your representatives. It's start a dialogue. And again, reach out to your local representatives in your community and say, look, this is what has happened because of this bill. This is what is done. This is what we now see. This is now what we go through. They wrote this bill in a proverbial vacuum. And they think it's the greatest idea in the world. We might not, in the industry, think it's so good. But tell them. Okay? If we cannot foreclose on late fines, fees, can we collect at sale and closing? Yes, but here's again another rub on that is debt is only good for 6 years. And if I keep my account current and all that's in that lien is late fees, penalties, and interest, and 6 years later, that drops off. It becomes uncollectible. I just have to wait it out. Do you have policies and procedures for the new laws that the HOA can purchase? Janet, that is a great question. Yes, $395 is a fixed fee. Let us know. Your associations will draft them up. Again, they're custom drafted for your particular communities. I don't mean to make this a sales pitch, but since I was asked, yes, yeah, $395 to get you all three. Just let us know. Since associations are now so restricted and city enforcement isn't, should we be sending enforcement complaints to the city? Absolutely. Yes, do that. I told all my managers to try and flood the city with complaints so that they maybe the city will push back against this. Yes, please do. They're the only ones that are going to be able to. How would you use collections? How would the use of collections agency work? Very poorly, Erica. Go to your attorney, Erica. Collection agencies are going to be subject to the exact same requirements we are. It's problematic. Tina, thank you. Add to the outside of your envelope. There you go, everybody. If you want it, here's Governor Polis's contact information. Any other questions, my friends? The bottom line is it's harder. There's no doubt about it. It is harder to tow. It is harder to enforce. It is harder to collect. Your job's got harder. There's no doubt about it. And I'm sorry for that. As you saw, it's few bad actors, as is always the case. A few bad actors made the problem for everybody. All I can tell you is, again, follow your collection. First, update your collection policy. Update your reserve, or not your reserve study. Update your conduct and meeting policy. Update your enforcement policy. Make sure your policies are compliant with the statute, and then follow them. That is going to be the big sticking point, is if we stub our toe. Owners, the availability of information is really easy out there. And there are a number of HOA, I would say anti-HOA, they call them, say, the homeowner advocates. There are a group of websites that are setting up to be able to help owners avoid compliance. And it is just going to be harder, and it's not going to get easier. And follow it. Technical mistakes can trip you up. And it is, again, there's going to be attorneys on the other side that are going to pick up on this. And they are the first thing an owner is going to call and say, I got this. They're going to say, okay, ask for this, this, and this. And if you don't get this, this, and this, we're going to push back and make them start over. So make sure that you are following everything you do, and make sure you get the new policies in place by August 8th. Let us know if you need them. We've got them drafted and we're ready to go. So any other questions? Thank you so much, everybody. It's been, as always, all sorts of fun. Like I said, the only real case out there was the one about reasonable notice for a foreclosure. And again, it's that goes to your attorney. So the attorney needs to make sure you're doing it accordingly. So with that all be said, thank you so much. I will stick around and answer any other questions you got. Or you can just log off and have a good time, and you will get your CMCA credit. But thank you, everybody. Yes, Tina. But now I'm depressed. Oh, I know I'm depressed too. But hey, it's job security. You can just refer to this as the Attorney Full Employment Act and Manager Full Employment Act. All right, Tina, what was your question? You said we can't charge extra for the letters, assuming that's to the owner. Yes. The certified letter, yes, but the extra stuff, no, because that's a cost of collection. So thank you, everybody, again, so much. Have a wonderful day. I'm so sorry, Mary. I'm confused about the towing from our parking lots, not streets. Can you walk through that, what we have to do? Yeah, okay. Towing. The bill requires a bunch of stuff on the towing company, like where to put the signs, what the signs have to contain. Okay, once you get the towing company compliant, if the car is not in a limited common element parking lot, okay, so if it is in somebody, I come into your community and I park in somebody's parking space, you or that owner can call to have that car towed immediately. If, however, like we've been discussing, it's just towed, it's just parked inappropriately. I come in and I'm a jackass and I park in 2 spaces. You have to first give me notice that I'm parked wrong. Okay, that's one. And then if you catch me doing it again, you have to give me another notice that I'm parked wrong, meaning put it on my car. Okay, then I do it again, then you can tow me. But you have to give me 2 notices, at least 24 hours apart, that I'm parked wrong, and I keep doing it. But the bill doesn't say I have to stay there parked wrong. I just have to do the exact same thing, and you have to tell me what I did wrong. So your notice has to say, you're parked in between 2 lines, jerk. Or you're parked in between 2 lines, put it on the car. Then if I move it, scrape it off, I move it, I come back, I park between 2 lines, you have to tell me again. You're parked between 2 lines, continue doing it, will result in towing. It's on that 3rd one that you can actually tow. Okay? So that's how that works. But again, you have to have all the signs. You have to have everything ready to go. Mike, it's $35 each. Put it in your collection policy, Mike. Let's see what happens. I don't know if it's fair or not. We'll have to work through that. Are the associations able to charge a certified letter fee to the owner? Yes, I think you can. Can we call out to get the drafts? You can call us and we'll prep them. They're not drafts. They're custom made per community. How many questions can you answer in 1.5 hours? 300. Yes. Thank you very much. I have a new record. Go, David. All right. Thank you so much, everybody. You are all so wonderful. And again, This is going to take some working through. There's no doubt about it. These are big, long, complicated bills, and we're going to get through them together. I promise. Yeah, it is concentrated, and a lot of it. I was told to slow down this time, and I thought I did such a good job. All right, like I said, I'll hang around if anybody has any questions on anything. I'll just hang around for a few more minutes. Oh, Janet, if you didn't hear, yes, the association passed on the noticing fee. Yep. It's not trash cans over the federal. No, it's not federal law, but it is city code that the owner is required to keep. And here's that rub, Laura. Owners are required to keep their sidewalks clear. Okay. How the city has been enforcing that is through the use of the association. You probably do not have that right anymore. So you, again, hammer the city. Make the city come out and enforce it. So can you go back to the 6-year debt drop-off thing? Yeah, there's a 6-year statute of limitations on assessments, and there's a 6-year statute of limitations on kind of that debt certain. So if it goes on more than 6 years, you probably cannot collect it. Now, that being said, if you sue and get a judgment, the judgment lasts much longer. But if you don't get a judgment and just rely on the lien, it drops off in about 6 years and it becomes uncollectible. If an owner is in the process of collecting 8.8, do we need to stop and start over? No, do not stop and start over. Just keep going exactly as you are, just adjust the interest rate. Can HOA tow if some person is trespassing? Yes, if the proper notices are there. Again, if the proper notices are there, you're going to have to work with your tow company. Can you block the walk for access? For a reasonable amount of time, yes, you can. And you have to post notice why it's closed, who to call to complain. What about the process of covenant enforcement? What about it? You need a new covenant enforcement policy. You're going to have to follow that covenant enforcement policy, and you're going to have to send certified letters of the delinquency. Or not the delinquency, of the violation, and you're going to have to give 30 days to cure. And then if they don't cure, you're going to have to send another one, and you have to tell them exactly what to do to cure. Oh, and I did forget to mention, and now that everybody's gone, your notice also must tell them how they can sue you, what can be done in court, what claims you can bring in court, and what claims they can bring in court. It's crazy. Can you please explain the 6-year term regarding liens? Again, assessment debt's only good for 6 years. There's a statute of limitations on it. So if you are applying all your payments to the principal and they're not incurring late fees, penalties, and interest, and they become historic, you have to sue to collect those within 6 years, or they're lost. Yeah, there's just a statute of limitations on it, and you're not going to be able to collect it. So you're going to have to make sure you stay on top of this stuff. Like I said, this bill really encourages lawsuits, not discourages them. Let me see. Meaning, if the homeowner already has more than $500 in fines, has been income enforcement process, do we need to start? No, nothing. This bill does not become effective until August 8th. So keep everything in place. Just be ready to play Let's Make a Deal come August 8th. Can you please say that again about telling an owner how to sue you? Your notice must contain, for a covenant violation, your notice must say, hey, owner, if you don't cure this, we can sue you in small claims court, we can sue you in county court, and you can bring actions against the association if needed. You're required to tell them what actions they can bring. It's the craziest thing I've ever seen in a bill. But a lot of people say, oh, I didn't know I could sue my association. Well, now you can tell them they can sue your association. It's all sorts of fun. But again, you're just going to have to follow your collection and covenant enforcement policies. These have become so important now, it's not even funny. Yeah, we are drafting compliant letters. Yep. And yes, we have wording for the notice. And yes, we'll make sure you get them. All right, everybody. It is now 1:30. I'm going to be cut off. Thank you so very much. Have a great day.